Welcome, everybody, to episode 11 of the Invention Laboratory. Tonight, we're going to talk about the Provisional Application for Patent, what it is, do I need it, and when should it be filed? Now, before we get started today, it should be understood that my viewpoints, methods, and opinions are not to be used as a substitute for legal advice. A strong relationship with a patent attorney should be established at some point during your invention journey. This information is purely educational, and it should be intended as a guideline for industry standards and common practices amongst product development professionals and manufacturers. If you need assistance with your project in preparation of presentation to a manufacturer or a buyer or company, please visit our website or request some information and set aside some time to speak. We specialize in product development, professional presentation materials, private label product development, marketing plans, and also licensing proposals. Our goal is to educate you as the creator so that you no longer need our help. You have the capability to do everything that's required to get your product the consideration it deserves. Now you just need the tools. Now, one of those great tools in our industry is the Provisional Application for Patent. The Provisional Application for Patent is an incredible tool created by the USPTO, or the United States Patent and Trademark Office. Under the United States patent law, a provisional application is a legal document filed with the USPTO that establishes an early filing date, but it doesn't mature into an issued patent unless you as the applicant file a non-provisional patent application within 1 year. Others will know that as a utility patent. So in a nutshell, when filing a provisional application for patent, you start a clock on your project that starts to count down from 1 year to 0. The goal during this period of time is to allow you the chance to make revisions to the project, acquire capital, continue research. You can seek a legal opinion from a patent agent or a licensed IP attorney, or you can just grant yourself perceived ownership as a bargaining chip during licensing negotiations. During that, you also get the rare opportunity to avoid some of the costs typically associated with a non-provisional patent prosecution, certain attorney fees, for example. It also gives you time to discern whether your invention's commercially viable. One of the advantages of filing a PPA is that it falls under the no harm, no foul umbrella during development. In other words, if you fail to file that utility patent at your PPA's expiration date, you're not at risk for your information becoming public domain. The only way that information is released to the public is if the application number is noted in a later published application or patent. That used to be a concern for people over the years, that if they didn't finish it and they didn't file the utility at the conclusion of that 12 months, that they were just kind of for lack of a better term, shit out of luck. But that's not the case. Also, there is additional filings this year where they're looking to expand that window, which will allow you to continue the provisional process a bit further or extend that process. Right now, it's not complete, but they are working toward that as we speak. Now that you know what a PPA is and also a little bit more about how it works, let's talk about whether or not you need one. The very simple answer here is yes, you do need one. The more complicated question is, when do you file it? You need to file this application as soon as possible, but it also has to be done at the right time. Well, Curtis, how do I know when that is? You'll know that by answering these following 5 questions. Number 1, have I completed an invention brief? That'll have a description, a sketch, general research, and an action plan. Number 2, am I financially prepared to execute a utility patent within the next 12 months? Number 3, do I have a team in place to perfect my presentation materials before filing? Things like professional research, design specs, a prototype, whether it's physical or digital, and also marketing materials for pitching this to corporations at its completion. Number 4, do I know what my limits are if I run out of resources? This is very important. In other words, will you be able to pull the plug on the project if it becomes a money pit? Number 5, have I selected an attorney, company, and/or consultant that has my best interests in mind? If you're secure in those responses, it's time to pull the trigger. The USPTO has a checklist that applies to new applicants that contains the minimum filing requirements. If you'd like to read an in-depth article on provisional patent applications, head over to the Invention Laboratory Facebook page or add me on LinkedIn. It's one of the articles that I recently published in my profile. My information's in the description box below. Hopefully that gives you a better understanding of the provisional application for patents, some of its benefits, and how you can use it in your next project. Thanks again for tuning in to episode 11 of the Invention Laboratory, and as always, reach out to me with any questions you'd like to have answered in future episodes. Until next time, creators, take care.